With the vote of no confidence expected in May, both the government and now the opposition have gone to the Supreme Court to seek clarification on the election of the Prime Minister. Opposition Leader Patrick Pruaitch made the announcement.
And constitutionality of Section 63. And the second matter is, second ground if you like, is the question of what day should a Prime Minister be elected.
The first claim that Section 63 subsection 2 of the Organic Law is unconstitutional and invalid. Section 63 subsection 2 stating that where two or more registered political parties have endorsed an equal number, being the greatest number, of candidates declared elected in the elections, the Electoral Commission shall so advise the head of state, and the head of state, acting with and in accordance with the advice of the Electoral Commission, shall invite the registered political parties with the highest vote declared in the elections to form the government.
Organic law on the integrity of political parties and candidates, Section 63, is unconstitutional. Now, this is a claim. This is a matter that the Supreme Court has to determine. At the basis of that claim is that under the law, any provision made by the organic law or an act of a parliament, any act of a parliament, all those provisions must be authorized by the Constitution.
The second claim that as per the Constitution, the Prime Minister's Office, Section 142, subsection 2, that the Prime Minister shall be appointed at the first meeting of the Parliament after the general election and otherwise from time to time as the occasion for the appointment of a Prime Minister arises by the head of state, acting in accordance with the decision of the Parliament.
The Prime Minister on the 2nd of August 2017, being on the first day of the sitting of the Parliament after the return of the writs, was unconstitutional on the basis that the election did not take place on the next sitting days after Parliament was informed who the candidate or candidates were for the post of Prime Minister.
Their lawyer Loani Henao stating the difference between the reference filed by the government and the opposition.
The opposition leaders have filed is under Section 18 of the Constitution. The one filed by the Attorney General, there were two filed by the Attorney General, number 4 and 5, Supreme Court reference number 4 and 5 by the Attorney General, were filed under Section 19 of the Constitution. Then the applicant, as in this case, must demonstrate to the Supreme Court that they do have constitutional interest or legal interest to bring such questions to be determined by the Supreme Court. So, Otsemna, we're going to the Supreme Court under Section 18 because we do not have that privilege to go straight to the Supreme Court to ask the Supreme Court to raise and determine those two questions which we dealt with.
The Prime Minister, along with the Attorney General and the Speaker of Parliament, are expected to be served a copy of the Supreme Court application. Adelaide Sirox Kari, National, MTV News.